live. All right. Good evening, folks. Welcome to Wednesday night's Kirks Law Corner Live. Christopher Hallett over there with E-Clause LLC. John Gentry down there with We the People V50.com. And I'm Kirk. We are going to go over John's petition of remonstrance that he has filed and the Tennessee Senate. So, how you doing, brothers?
Ready to rock, man. I'm ready to get ready to do this, get this stuff out there, and work on the step-by-steps, what to do, who to talk to, what hurdles you might have, that kind of stuff. As I'm sure you guys are well aware, yesterday's hearings, Dianne Feinstein pretty much confirmed everything I've been saying on this show.
Right
up to and including how they're going to try to use the Emoluments clause to impeach the president, considering the fact that was the line of question that she was following when she led into that one. So again, that's on a different video further back, but I'll when John's done, I'm going to go over that a little bit more. And without further ado, I'm going to turn this over to John.
All right, I'm just getting some shares going.
Right up to and including.
Got it.
Okay. Wow. What a last couple of days. So I filed a petition of remonstrance. I'll tell you about the filing process. I've been communicating to the General Assembly that this is coming. And so the General Assembly and the office people, it's pretty obvious to me, they had this all planned out. I mean, from the get-go, what was going to happen. They've got it all planned out. Chris, I don't know if you remember, I asked the other day, why are they trying to keep me out of the House? And I figured it out. But here was the process. I went into the legislative office building, and I went over to the House, and the chief clerk for the House was out, and I don't know what they are, aides or something that she has. They said, we can't help you. You have to wait for the chief clerk. So I was like, all right, so I'll go over to the Senate. Senate office doors are closed. Nobody's there. And I just saw this random guy in the hallway. I didn't know who he was. And I said, hey, where's the clerk for the Senate? Where's the clerk's office? Isn't that over there? But the doors are all closed. And he's like, what you need? And I said, well, I want to file something. He's like, what are you going to file? And I said, well, it's a remonstrance. And he goes, oh, hold on just a second. And then he went and made a phone call, and he came back, and I introduced myself to him. It was Alan Whittington, I believe was his name. Really nice gentleman. And so he said, go over to the Senate floor, the Senate chamber. Russell Humphrey, the chief clerk, is waiting for you over there. So I went over to the Senate. Really, really nice gentleman. He's like, what is this about? Tell me about your remonstrance here. And I spent about 20 minutes talking to him, explaining, the fundamentals of it, the redress that I wanted out of it. And so he file stamped it and entered it in. And he said, well, we're going to enter this in the record on Friday. Not, you got to question everything with these guys because they're always orchestrating something. So there's probably something there as to why it's getting entered in the record on Friday. I'm not going to speculate, but there's probably something to that. So then I go over to the House, and they're like, well, she's still not here. She's probably going to be back in another hour and a half or so. So I'm like, oh, good grief. So I go wait out in the corridor, and I see her walking down the hallway. And I followed her into her office, and I said, hey, I would like to file my petition of remonstrance. And she said, you're going to need a member to file that on your behalf. And I said, under what rule? And she said, well, that's our process. And I'm like, what process? A remonstrance hasn't been filed in Tennessee since 1850. I was like, what, did you go over the archives and find some process from the past? She's like, yes, you should go over the archives and research that. I'm like, you're the one telling me that this is the process. And she said, well, you should go. I was like, I am not going to go research this. Not at all. You're the one telling me this is the process. I'm telling you, I have a right to remonstrate with this clerk's office and file it here. And she's like, well, and so I picked it up, and it's a lot. I mean, it's like 4 inches thick. And I said, I would like to file my petition of remonstrance. And she said, I'm not going to accept it. And I said, so are you refusing to recognize a guaranteed right of mine? She said, no, you have to have a member present it. And I said, well, I think you're depriving me of a constitutional right. And I took out my phone and I said, will you say this for the camera? And I turned on my video, and she ran in her office and closed the door. Totally ran in her office and closed the door, and did not want to get it on the record that she was denying me.
Yeah. Yep.
This is not a problem. It is not a problem because I have my handy dandy Mason's Manual legislative procedure. I have my handy little book here, and in section 418, it says questions come before the body through communications or petitions. Well, that's a damn communication that I sent out to the entire General Assembly with a copy of my remonstrance. So it has now been presented to the body, and I should be heard. I don't care if a member files on my behalf. It's already been presented to the entire General Assembly. So
that's the thing. This is a right retained by the people. There shall be no rulemaking that would abrogate the rights of the people. That's Miranda versus Arizona. I don't care about your rules. Your rules damn well better include the procedure, right, to hear petitions of remonstrance, because that's a right in the Constitution. And what does it say? Constitutional provisions are mandatory.
Actually, it says
that they have the power to make rules whenever necessary, right on the spot if need be. So if you go to get in there and they're giving you a hard time, well, heck, right here it says you can make rules at any time. So where there's a right, there has to be a remedy. So,
Mason, there's two roles in here. Number one is that questions come before the body through communications. So I've already communicated my remonstrance. I emailed a copy to them. And now that they're trying to deny me entry into the House record, I'm going to email them the 700 pages of exhibits, which is going to be kind of a pain in the ass for me because I have exhibits, I think it's A through Q that I have to file. And some of them are 17 megs, and I think my max is 20 megs that I can email. So I'm going to have to send out, and I got 131 people, 131 senators and representatives. And so I have to open up each email and attach it. It's a little pain in the butt, but you guys know me. There ain't nothing stopping me. I'll get it filed to them. I don't care. So
why don't you just do one email, attach it to one email, and send it to all of them?
Nah, I like doing it one at a time. But it's just process. But maybe I'm just a glutton for pain. I don't know. But
only
well, maybe I don't know. But anyway, so it's not gonna stop the process. They cannot stop the process. Now I gotta share this. This is really what I wanted to share tonight, and I learned this from Kirk. We are a team here. Chris got us into the legislature, and Kirk freaking blew my mind. Kirk exposed, whatever you want to call it, deep state, cobble, whatever it is, Kirk exposed it. And when he gave me, like Chris said, we need to file with the legislature. And then Kirk came in and said, the code isn't the law. And he sent me this beautiful Supreme Court opinion from Idaho that says exactly that the state code is not the law. And in that case, they said it's a representation of the law. But I'm gonna share this with you guys and show you this is ugly stuff, people. I mean, this is really, it is a alteration of the fundamental form of our government. It is multiple declared acts of tyranny going on here. Really bad stuff. And they did not want to hear this. Chris, you remember I told you I didn't understand why they're trying to keep me out of the House when I filed in the Senate. You remember that, right?
I sure do.
You're like, John, you're playing three games at the same time here. You're playing Monopoly. You got the Monopoly money that you're playing with. You got a chess game, and it's also a poker game. And you're absolutely right. It is. That's a great description. We're talking poker, Monopoly, and chess all at the same time. Here's this. It's a cross between chess and poker, trying to bluff me out and keep me out of the House. But I'm going to outsmart them because Mason says questions come before the body through a communication. So I just emailed the entire General Assembly. There's my communication. It's before the body. Now you got to hear the damn thing, whether you like it or not. But here's why, Chris. Here's why. They know because I provided them a copy in advance. I sent a draft to my representatives from my district before I met with him. I was like, here's a draft of it. And they know that I'm demanding impeachment of bad actor judges. Who can impeach? It's the House. The House has the sole power of impeachment. And that's why they're trying to keep me out of the House. They're recognizing my right to remonstrate by allowing me to file into the Senate, but they're trying to keep me out of the House because they don't want to impeach these bad actors. That's why they're keeping me out of the House. They're going to try to appease me. Maybe they'll give me some of the things that I want. And I'm going to go over that tonight. The things that we're remonstrating here are, they got to give me some of it. Some of these demands for redress, they have to give me. And I'm going to go over this here in a few minutes. I've said it to the chief clerk. I've said it to the representatives that I've met with, that this is a freaking gimme. You have to do this. If you don't, then you've just evidenced the corruption of the entire General Assembly. You have to give it to me. But let me go over what the hell, Kirk. This is all Kirk Pendergrass right here. What I did was I researched it and I proved it beyond any reasonable doubt that our form of government has been altered through multiple declared acts of tyranny. Our government has been fundamentally altered, and we need to fix this big time. But let me share what we got here. So this is the remonstrance that I filed with the Senate chief clerk. I've had legislators call me up, email me, and they're like, Mr. Gentry, this is some heavy reading, or Mr. Gentry, I'm so ashamed that I didn't know what was going on, or Mr. Gentry, this is just an incredible amount of information to take in at one time. That's the feedback that I'm getting from these guys on this thing. But let me jump down to the table of contents here. Here's the most important part of this thing, and this is, I'm telling the people, this is 100% Kirk Pendergrass. But I took what he taught me, and then I substantiated it. So the Tennessee Code Commission must be dissolved and certain statutes repealed or made void. So that's on page 30. So let's jump down to page 30 here. So I went through and said, here's the problem with the statutes that I'm going out there. And I said, it's no surprise that the people are subjected to constitutionally repugnant statutes, since members of the bar are writing legislation without oversight and without act of Congress in violation of the separation of powers doctrine. So I put in this quote. I actually found this quote, and there's so many people that are involved in this. This was Martin Lynch. The night before I filed, he's like, you got to go watch this video from Scalia. And Scalia did this. He's like, he asked when he gives seminars, what do you think makes America such a free country? And a lot of people say, well, it's our Bill of Rights. It's the freedoms that are in there. And he's like, you're crazy. Every banana republic in the world has a Bill of Rights. He said, our framers called that a parchment guarantee. And that's what it is. It's worth the freaking paper that it's written on, because we cannot enforce our rights. What it is it's the separation of powers. And that's where we have broken down people. Okay, you're gonna crap yourself on this out there, guys. Tennessee Code annotated Title I, Section 101. There is created a Tennessee Code Commission of 5 members composed of the Chief Justice of the Supreme Court, the Attorney General and reporter, a director for Office of Legal Services, and 2 other members appointed by the Chief Justice. We don't know who the hell they are, but he gets to appoint them under this. Well, this is pretended legislation, which is a declared act of tyranny and our Declaration of Independence. So here's the thing. So Tennessee Constitution, Article 2, Section 26 says, no judge of any court or attorney general shall have a seat in the General Assembly. That's really key. No attorney general, no judge shall have a seat in the General Assembly. Why do you think they did that? It's common sense. Because if you have judges and attorneys sitting in the legislature, they're going to construct legislation for their own advantage. And our founders knew that in Tennessee, and that's why they said no judge or attorney general shall have a seat in the General Assembly. This is the crazy part. Tennessee Code 1105. The Tennessee Code Commission is authorized to annotate, edit statutes, codes, and session laws of the state of Tennessee, now existing and to be enacted in the future. This is key, people. They can edit. The Attorney General and the Chief Justice can edit the statutory, the lawful acts of Congress. They can edit it. But here's the really tricky part. Statutes, codes, and session laws. Well, statutes are the lawful acts of Congress. Session laws are the specific acts of Congress of a specific session of Congress. What the hell are codes? I don't know. I think codes might be something that the Tennessee Code Commission makes up. That's what I think they are. We're not sure because it doesn't say. It doesn't say what the codes are. So I went through and I just defined, what we talked about. Now, code, when they say, Idaho Code or Tennessee Code, the code is a collection of the laws, rules, and regulations of the state. That's what the code is. Codes compiled, who knows what the hell that is. So essentially, what this Tennessee, it creates a commission who have unlawful authority to compile codes, perhaps made up by themselves, and who are authorized to edit and annotate the acts of Congress. Clearly, the legislative legislative authority of the states vested in the General Assembly and the Senate pursuant to Tennessee Constitution Article 2, Section 3. Who reviews the editing and annotating of attorneys and judges who comprise the Tennessee Code Commission? Nobody. I don't think anybody reviews their edits. I don't think anybody does. So the first step we got to figure out here is we have to determine if in fact the Tennessee Code annotated is acts of Congress and whether the language reflects the intent of Congress or whether merely codes purported as lawful statutes are an undercolor of law. So respectfully, the legislature has authorized 5 people who are all attorneys and judges to annotate and edit the lawful acts of Congress without any oversight whatsoever. So you look at TCA 111, upon certification of approval by the commission. So they're going to approve their own shit here, people. Upon certification of the approval for their own edits, each volume and supplement, I don't know what that is. I guess that's maybe some new codes they put in there. So certified shall be enforced. Shall be enforced. Wow.
Which is what my dad always says about, of course it's legal. If you don't believe me, ask me. What the hell is that? Right?
So I wrote it here. I was like, esteemed senators and representatives, please take pause and carefully consider the language shall constitute prima facie evidence of statutory law of this state to be received, recognized, and referred to in all courts, agencies, departments, proceedings in the state as official compilation of statutory law. What is statutory law? I defined it back up here. Statutory law is acts of legislature declaring, commanding, or prohibiting something. So they're saying that the codes are lawful acts of Congress that they compile into, which is a declared act of tyranny. That the Declaration of Independence talks about their pretended legislation and gathering in unusual places to create this law. And this is the statute where it is. And I want to read this. So that the statutes, and here they do it again, the statutes, codes, and code supplements, let's throw some more crap in there, shall constitute prima facie evidence of the statutory law of this state to be received and used in all courts. This is freaking scary, people.
You mean
I'm
word
not
salad?
Go ahead.
So you mean word salad?
No, I'm talking treason here, Chris. This is treason against
that's what I'm saying. Basically, there's, what John is saying, just to kind of, break it down a little bit for you is, it doesn't matter what you say. They're gonna come back and come up with a rule, a code, a statute, or some shit made up by them that says, no, it's orange. And it says so in this thing that I wrote. So this is basically where John's going with this. But anyway, go ahead, John. I'm loving this.
So here now get this. So the commission comprised primarily, if not completely, of attorneys and judges, is further granted the power to lobby Congress in Section 114 without registration of lobbyists. Now, Chris, this frickin' blew my mind. The commission may prepare and submit to succeeding sessions its recommendation in substance and form, or the repeal or amendment of certain statutes or any portion thereof, and submit bills for the accomplishment of such proposed revision, repeal, or amendment. This is the Attorney General and the Supreme Court Chief Justice. This is
Both members of the bar.
okay. Now, this is what drives this point home, people. One can well imagine the outrage. Chief Justice Roberts of the Supreme Court of the United States made recommendations to the United States Congress for the revision, substance, and form, repeal, or amendment of certain statutes. One can well imagine the outrage if the Supreme Court of the United States were editing the lawful acts of the United States Congress. These facts are so repugnant to our form of government and separation of powers doctrine, it frustrates rational thought. He has called together legislative bodies at unusual places. Well, that unusual place is the Tennessee Code Commission, for the sole purpose of fatiguing them into compliance with his measures, which is exactly what Chris just said. They pull out some little thing about some little code. All right, here's how this works, people. So let's say an attorney who's well placed in the legal hierarchy of the cabal, deep state, whatever you want to call them, and he loses a case, or he wants another emolument or something. So he goes to his buddy judge on the Supreme Court, the Chief Justice, and says, hey, why don't we tweak this little part of the Tennessee Code? Let's change this from a no to a yes, or from an if to a any, because that's all it takes to change the law, is just to change one little word, flip around a little phrase, and edit it. Imagine if Chief Justice Roberts had the authority to do that. Now, think about this, people. Think about this one. If the Chief Justice of the Supreme Court of the United States has the power or the authority to recommend to Congress the repeal or the change in form or substance of the United States Code, and propose a bill. Here's the bill, guys. I wrote it up for you, right? Now, who is it that oversees the constitutionality of our laws? It's the Supreme Court, right? So when you challenge a statute as unconstitutional and you go to the Tennessee Supreme Court, the Tennessee Supreme Court is the one that certified, edited, annotated, and made recommendations, and perhaps lobbied Congress, perhaps inserted their own freaking code, which is not a lawful act of Congress, and you go challenge this before the Tennessee Supreme Court. Do you think they have rendered themselves incapable of performing the basic function of their office? There is no doubt that the Tennessee Supreme Court has rendered itself incapable of rendering decision on the constitutionality of state statutes, because they are the ones writing the state statutes. This is a declared act of tyranny. Chris, what's the one on, do you know it off the top of your head, the pretended legislation? I can look it up here real quick. I'm going to Google Declaration of Independence here and look for pretended.
Oh, for suspending our legislatures and legislating for us in all cases whatsoever?
No. This is the Tennessee Code Commission. This is a declared act of tyranny in our Declaration of Independence. He has combined with others to subject us to a jurisdiction foreign to our Constitution. He has combined with the Attorney General, the two people that he appoints, whoever the hell they are, to subject us to a jurisdiction foreign to our Constitution. and acknowledged by our laws, giving his assent to acts of pretended legislation. This is exactly what the Tennessee Code Commission is doing. This is exactly what every other state out there is doing. The bar is legislating after the fact. And I mean, you think about this, people. Do you think that any congressperson, representative, or senator is going to go check the Tennessee Code annotated and say, is this the legislation we wrote? Now, here's I'm gonna show you guys this thing. This is the last thing, and then I'm gonna shut up for a minute because I gotta breathe, man.
I was going to expand on what you were just saying there, John, because I found a couple of more. For suspending our own legislatures and declaring themselves invested with power to legislate for us in all cases whatsoever, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments.
That's it.
And there's also, he has excited domestic insurrections amongst us and has endeavored to bring on the inhabitants of our frontiers the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions, right? So I wanted to throw those couple out there too, because if you look at recent news and history, that last one I mentioned is actually very prominent when you come to this whole social justice warrior movement, right? So I'm going to shut up now and go ahead, John, and take the wheel, brother.
I've been challenging the Government Tort Liability Act through the Supreme Court. I think they took it down. I think it's gone. TCA 20. I got to look up the statute. Take over for a minute, somebody. I got a second.
So a lot of where this comes from here, when we're talking about this stuff, this particular part here, where I got it from was Peterson versus Peterson, Idaho Supreme Court case. And when you read what the judge's opinion is written in there, he lays this all out, date by date of how it went, how it came about. And for Idaho, it says that the attorney general, whatever, gets the member, the bar submits 7 people from the bar, and then they select 3 out of the bar to write this book that they call the commission, right? The commission calls the book the Idaho Code. And in my mind, that's an attempt to deceive the people into thinking that the book called Idaho Code is actually the law. And this is where Eisman, Chief Justice, Supreme Court of Idaho, who just retired here 2 years ago, he lays this all out. It's just a book written by 3 guys in the back room, and they just named the book the Idaho Code to purport to settle that that's the law.
So
and
that basically, to what Kirk was saying, he has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records for the sole purpose of fatiguing them into compliance with his measures. That's pretty much exactly what Kirk is explaining right now.
Yep. They're not fatiguing them. Well, I mean, I guess it would be wearing them out trying to write this whole sucker, right?
Dragging you through a process that looks like this, that's fatiguing them. That's what it is. That's the design, the malicious design, right?
That would be a malicious design. So in Peterson versus, this is 2014 here, Idaho Supreme Court, and Eisman flat out says the Idaho Code is not law because it's a book written by 3 people. And like what John was sharing here a little bit earlier, that they can edit. Well, mine just basically says the same thing, as if they can edit this stuff, but they're just compiling, and it's supposed to be prima facie evidence, and the same verbiage there is it will be accepted by all the branches of government. Go, John.
I found it. So let me share my screen here. This one is tripping me out, guys. This one is really tripping me out. This is my appendix that I filed in the Supreme Court of the United States. I swore an oath under perjury that everything in this document was true and correct. Under the United States Code, I swore under penalty of perjury. So here is Tennessee Code annotated 2920-205. And here's another point that I want to make. So the Tennessee Code Commission compiles and organizes the Tennessee Code, right? They compile and organize. So they're the ones that create all the structure, right? These are freaking attorneys trying to deceive us by sticking shit in like you don't even know what the hell the title is about. They do this shit all the time in the Tennessee Code, is they'll slip a little, like, okay, parties to the proceedings, right? They have, that's the title of a statute, parties to the proceedings. And then they throw down the bottom that if you challenge the constitutionality of state law, you have to notice the Attorney General. So when you come in there and you challenge them on this bullshit that they put in there that is unconstitutional, they say, oh, sorry, you didn't notice the Attorney General, so we don't care. This is the trickery of these freaking bar members sitting in the Supreme Court and the Attorney General's office. But here, I'm getting off hand. But take a look at the title of this thing, TCA 2920-205. I swore that this was in the Tennessee Code annotated. Removal of immunities for injury caused by negligent act or omission. And then what the hell is this? Exception, immunity, year 2000 calculation errors. What the hell is that shit, right? That title, and this is what I'm talking about, the title of things. Like, what the hell does that title mean? Who knows, right? Like, you would, if you, let's go back to what the code looks like, right? So let's say you're going through here and you open up a chapter and then you see this year 2000 title, right? You're like, well, I don't need to know anything about year 2000, and you keep going, right? They make it difficult to find things. But let's go back to this. So immunity from suit from all governmental entities is removed proximately caused by negligent act if the injury arises out of, let's see. Do they have, yeah. So then they go in here and they say false arrest, malicious prosecution, intentional trespass, abuse of process, libel, slander, deceit, interference with contract rights, infliction of mental anguish, invasion of privacy, civil rights. They just put a laundry list. I'm surprised they didn't throw murder and kidnapping in there. I mean, it's just a laundry list of shit they can get away with, right?
They have murder and kidnapping in there. They protect themselves by mock trials. We'll investigate that, and we'll see if we're going to indict them.
Now here, Kirk, check this out, brother. Chris, you got to see this, man. Okay, look at the code. Tennessee Code 2920-205, right? Let's go look at the Tennessee Code. Here it is right here. So I just came in here because I was going to show you guys this online tonight, right? And so here's Title 29. It's gone. It's freaking gone. They took it out. All of that shit that I just filed at the Supreme Court, they just got freaking busted, and now they're trying to play cover ass by taking it out of the Tennessee Code.
Yep.
So they repealed their own code. Like, well, these guys are so toast, man.
Only online, right? I bet you go get the book, their book, because this Tennessee Code you're looking at it is a book, their book. That's not really the statutes. That's just their code book that you're looking at. written
Yeah,
by
well,
the people.
but I mean, look at this was the code. This was the code. I copied this off of that same page on the website. I filed this thing just 2018. I filed this thing, and all of this. So all of this is gone. Now here's the tricky, and this is the tricky shit they
We
did.
got to go to chapter 20, title 29, chapter 20, section 205.
Did I screw something up? No, 29 is gone, brother.
No, go back one page. Now go down to chapter 20.
Oh, maybe it is. All right. I probably, yeah. All right. I screwed up. Sorry, guys. It's still there. I was like, holy shit. They got rid of it. Okay. So I thought, my bad. I got, no, it's gone. No, 205. My bad.
That's 209.
Yeah, 205. My bad. It's still there.
Yep, it's still there.
Okay, my bad. They still got their shit in there, but I still question whether Congress passed that because I have a hard time believing that Congress said they could do all this stuff and get away with it.
Congress can't do that.
No, I don't think they can. It's unconstitutional.
They can't. That's part of the stuff that they can't do.
Right. That would be protecting them.
Well, they're saying
Their
you can't.
crimes.
They're saying
And telling us that we can't file suit against them. Tort claims.
Here's the thing. So, and look at the tricky lawyer language. Immunity from governmental entities is removed. So that means it's removed. You can sue them for this shit, right? That's what that means. If immunity is removed, right? Chris, you can sue them for it, right?
That's right.
But then they say, except if the injury arises out of. That's tricky lawyer language there, ain't it?
You mean shit made up? No.
Attorney language.
Yeah.
That's right.
Yeah, thank you for correcting me.
They are not lawyers. These are code speakers. They're attorney.
And then they go, and then they go into their laundry list of crimes and tortuous conduct and say, yep, all that stuff, you can't sue governmental entities. And is it governmental entities that inflict mental anguish or invade your right of privacy or violate your rights? No, it's bad actors. And if you try to sue the bad actor, they're like, oh, sovereign immunity, judicial immunity, you can't sue them. And so
wouldn't that be them trying to be sovereign citizens? Because they're citizens. Citizens are the elected official or appointed into a position of public trust. That's what makes a citizen.
Yeah, that's what I think too.
So they're trying to claim sovereignty. That would be a sovereign citizen. Is that the sovereign citizen movement that Southern Poverty Law Center is talking about?
Yeah, I mean, are they trying to deflect and accuse us of the shit they're doing? Because that's what it sounds like, right?
Sure is.
So,
hey, that's an old school trick, right? Accuse somebody else of what you're actually doing.
Oh, that's reverse prosecution, baby. Reus excipiendo fit actor, right?
Yeah, so that whole section that we just went off of, and I ran on for a little bit or a lot, but what Kirk uncovered, and then what I went and proved, is that we have the Chief Justice for the Supreme Court of the state who can edit the lawful acts of Congress, apparently insert their own codes, I don't know, and lobby Congress. The Chief Justice, they have judicial power. That's the only power granted to them. And it is repugnant that they can lobby Congress and hand them the bill. Now, you think about that. If the Chief Justice hands a bill to Congress and then Congress passes that, do you think you're going to get a fair analysis as to whether that statute is unconstitutional or not?
Chris, do your screen thing real quick. I'm stuck over here.
So, I mean, how they have rendered themselves incapable of performing their basic function of determining whether statutes are constitutional or not. It's crazy. I can't believe they did it. And they've been getting away with it for years. Did I lose? Oh, there we go. How's that, Kirk?
No, I'm still jammed up over here.
I had it. Oh, there he is. He's coming up. Give him a minute.
Chris, share.
No, my screen's still stuck.
All right. Hang on a minute.
Chris, you share and try it.
I'm going to be going over this in a minute. So this is where I kind of tie together what John's talking about. So,
but one thing that I am excited about is they accepted the remonstrance in the Senate, and he said definitely, you're going to get in front of the committee. I'm still going to bitch because it's addressed to the General Assembly, and a petitioner has a right to present his own petition to the body to whom it's addressed under their rules. And I addressed it to the General Assembly. So if they want to break their own rules, I'll keep remonstrating as long as I have to.
Kirk's saying he's still not. I can see you moving over there, Kirk. Is your screen working?
Oh, wait. Now just all okay. There we go.
Okay. All right. Good.
Okay. Yeah, somebody was just making the comment here. I'd like to address something about all these jobs, right, that are being lost or whatever from the government shutdown. At least I think that's what it was talking about. Why you want people to lose their jobs? Looks like all the furlough people will. Let me explain this. Just a kind of a quick short version. March 23rd, 2017, Trump made an executive order to do an audit of the entire executive branch. Okay. We've talked about this before on the show for over a year now. And Chris has actually used that executive order because in Trump's order there, he asked the people to report on anything that they think whatever needs to be abolished or changed, altered, reformed, or abolished. We have that right? Correct?
That's why I wrote my notice of appearance exactly as I did. I mean, It didn't get any plainer English than that, right?
So the reality here is all of those jobs that have been shut down are the quote unquote non-essential parts of government. Let me translate that for you. Those would be the unlawfully created parts of government. Those would be unlawful emoluments. Those emoluments aren't supposed to exist in our form of government. Look, I know a couple of people that have been affected by this personally. So, I understand, and I have sympathy. I do. But the reality is this is the new government. We're getting back to the de jure form of government. We're getting back to the rule of law. We're getting back to the Declaration of Independence, the Constitution for the United States of America, and the Bill of Rights. That was by proclamation, December 10th. Technically, December 8th is when it was written, published December 10th, 2017. Okay, this has all been laid out. If you haven't been following along with us, following along with what Trump's actually been doing, what he has actually done and set in motion and set in place, this is all going to be new to you. For us, who's been following since day one and before, since the beginning of his campaign, I've been following since the beginning of his campaign. Okay, so I know what he is working on and what he is doing because I have paid attention. All this is an elimination of all the agencies and agents in government. Some of them got consolidated, right? Let's say they had 70 people working in this department, and we're like, no, we actually can do all of that with about 5 people. So 65 jobs just got eliminated because we, the taxpayers, can't afford to pay them. And not only that, the Constitution doesn't allow them to be there. So this is the new reality, guys. Government's not going to open back up.
Yeah. Well,
this is be shut down.
Yeah. Some of it will. The bare bones, just prosecute bad actors for capital crimes, and that's going to be pretty much the standard version of it. Everything else is more than likely going to hit small claims court, right? Unless you want to go to a trial by jury, right? This is what we always talk about, the difference between the theory and the practice. We're practicing what we're preaching, right? We're trying to teach you guys the theory. This is an example of that theory. Those malicious designs of men must be thwarted. This is why I put the board up here, to teach you guys what the design looks like.
Look at you go over there with your loop-de-loops.
Well, it's perpetual litigation, financial gains and advantages, right?
And profit.
Right. So all of these things.
How do you make a profit off of tax dollars?
Well, and again, this goes to where they've hidden the emoluments of government through this word they've rewritten over top of it that they call entitlements, right? Where they just divide out the money and blah, 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 right? Redistribute the wealth and play Robin Hood, right? They get to say that politically they're playing Robin Hood. They're taking all the political advantage and the political gains for themselves. All of them are. This is the difference between entitlements and emoluments. Entitlements are black and white or green and white. Emoluments are all three. So the stuff that John's talking about and that Kirk was talking about is, those are all symptoms of this problem, right? So when I went in and said, okay, I'm going to share that with you real quick, because some people have said, oh, Hal's full of shit. He never asked that question. Well, here's the question, right? How do you explain how you do not know the difference between unlawful entitlements versus lawful emoluments? And then the maxim I put is, a person is considered the possessor who ceased possession through injury or fraud, right? So knowing full well that the whole damn pyramid scheme is a constructive fraud and shit show, right? So when Dianne Feinstein asked the Attorney General about the emoluments clause, I will leave opposing counsel to ponder the following question, as I am confident the Congressional Oversight Committee or committees will be asking them. And that's exactly what happened. And I'm going to play the soundbite for you as to exactly the way it was asked. The fact she couldn't even pronounce the word emolument, right, Kirk? just
emoluments, them damn moles in there.
Right? So watch... Let me go ahead and get that. Let me get that through. Let me just get that out there, because this is really going to help a lot of people understand the show tonight. I forgot I have to share my audio here. There we go. Okay.
It's actually...
You guys hear that? Okay.
People don't understand what the word corruptly means in that statute. It's an adverb, and it's not meant to mean with the state of mind. It's actually meant the way in which the influence or obstruction is committed. That's its adverbial function in the statute. And what it means is, using it in the 19th century sense, it meant to influence it in a way that changes something that's good and fit to something that's bad and unfit, namely the corruption of evidence or the corruption of a decision maker. That's what the word corruptly means, because once you dissociate it from that, it really means very hard to discern what it means. It means bad. What does bad mean?
Let me go on, because my time is so limited. You argue that and I quote, the Constitution's plenary grant of those powers to the president also extends to the unitary character of the executive branch itself. Specifically, you argue, and this is a quote, while Mueller's immediate target is the president's exercise of his discretionary powers, his obstruction theory reaches all exercises of prosecutorial discretion by the president's subordinates, from the attorney general down to the most junior line prosecutor, end quote. So if the president orders the attorney general to halt a criminal investigation for personal reasons, would that be prohibited under your theory?
Prohibited by what?
By
the Constitution.
The Constitution.
I think it would be. I think it would be a breach of the president's duties to faithfully execute the law. It'd be an abuse of power. Whether it would violate a statute depends on all the facts and what statute someone would cite me to. But I certainly think it would be an abuse of his power. And let me just say that the position.
Would that be the same thing if an attorney general fired U.S. attorneys for political reasons?
No, because U.S. attorneys are political appointments.
Yeah, you can fire them.
According to news reports, President Trump interviewed you and asked you to be part of the legal team defending him in the Mueller investigation twice. First in the spring of 17, when the investigation was just beginning, and again earlier this year. Is that correct?
No. I had one conversation with him that related to his private representation. I can describe that for you. That was in June of 2017. That's the only time I met him before I talked to him about the job of Attorney General, which obviously is not the same as representing him.
Have you discussed the Mueller investigation with the president or anyone else in the White House?
I discussed the Mueller investigation, but not in any particular substance. I can go through my conversations with you if you want.
Well, not at this time, but I may come back to you and ask you about that. I don't want to take any more time. Thank you, Mr. Chairman.
Each senator gets about 10 minutes in. That's questioning.
Oh, I must have passed it.
A stipend attached to some office.
There it is.
Be looked at.
Crap. Figures. I'm going to get a commercial in here.
Democrats have become party of.
Chris, what are you doing, brother?
Oh, just.
That is a breach of his constitutional duties, whether it also violates a statute, depending on what statute comes into play and what all the facts are.
Including the Emoluments clause of the Constitution.
Well, I think there's a dispute as to what the Emoluments clause relates to. I have not personally researched the Emoluments clause. I can't even tell you what it says at this point.
Dianne Feinstein.
Okay, I got to stop you right there. Notice it's like somebody sucked the air out of the room, right? He's loosening his tie, and and they know damn well what this is. This is why we always joke about it on the show. Did you go to law school? Did you pass? Right? This is the kind of crap that we're talking about. This is what I call the frickin' political two-step, where they actually know what it is. They don't know how to respond because it's never been.
Yeah, I like Susan's comment because I thought Kirk would get a kick out of it. She called it emoluments.
Right, exactly. So it's I'll jump back out of there and let you guys take that back over. But when we're going through these things, these specifics, okay, of what is actually going on, to me, that's hunting elephants with a BB gun. I'm one of those less is more, and I want all of the stuff that I can see as well as the stuff that I can't see, which is hidden in the advantages. And the reason I know that is because of having walked those corporate halls. I know what the difference between an advantage, a gain, and a profit is, right? So that's why I said I know this business and can manage it forwards, backwards, upside down, left, right, et cetera, et cetera, et cetera. So,
well, here's the thing is, like, with her, when she asked the question, it's like she doesn't even know where it's cited. Article 1, Section 9, Clause 8. Boom. Okay, so when he gave
13th Amendment.
Also the 13th Amendment. Okay, the original.
Yep.
But the thing is when she said it, it's almost like she doesn't know what the hell she's talking about, and is expecting him to just go, well, yeah, that would be an emoluments violation. Well, what would be an emolument? You guys don't even know what the hell you're talking about, let alone how to say it correctly. At least one of you.
I wanted to go over some of the successes with this remonstrance process. That hasn't even been heard yet. Hasn't even been heard, but I want to go over some of the success. If you guys haven't been listening to us, a remonstrance is a formal written protest to your government. You can file, actually, a remonstrance can go into any branch of government, but we're advocating that it goes into the legislature because there's more of them. But a remonstrance is a written protest for redress of grievance for against government policy or government officials. That's what a remonstrance is. So we've been advocating this. I just filed mine in the Senate. They're kind of shitting bricks because this is, we've called them out based on Kirk's work and said we've got the Supreme Court justice lobbying Congress, editing acts of Congress. Who knows what the hell they're doing in there, along with the Attorney General, rendering themselves incapable of performing their basic function of office, which is to determine whether statutes are constitutional or not. If they're lobbying for a statute, how possibly can they be impartial as to whether the statute is constitutional or not? So big frickin' mess, big violation of separation of powers. Kirk, it's one of the strongest arguments in my remonstrance. It added a tremendous amount of substance. Thank you for educating me on that. It is shaking some branches and the leaves are falling, brother. But I know some of the success.
We need to hammer him with the reality of the totality here. Is in and of itself an emoluments violation. They have created positions allegedly in government that allow them to subvert the law and claim that it is the law and purport it to the people as law and enforce it on the people as law. And not only that, it creates all of their jobs in the judicial branch. The bar itself is in control of everything, including the judicial branch, because they're going in through the legislature, in the executive, and then through the judicial.
Well, and here's the problem with the Supreme Court justice. So the Supreme Court justice, along with the Attorney General, two buddies, we don't know who the hell they are, but they can be picked by the Supreme Court justice. I assume that's a couple bar buddies from a high-powered law firm, and they just go in and tweak it. They tweak the law and they say, I want to make a little bit more money for my attorneys. I'm going to change this little phrase just a little bit. I'm going to slip in a new code here. And I don't think anybody's going to notice. And it looks like law. It looks like it. So huge problem. But I want to talk about the successes. So I emailed the entire General Assembly and said, hey, we got a chance to heal this nation, guys. Let's work together, right? Nobody responded. Out of 130 representatives and senators, nobody even asked what's a remonstrance or what are you filing about or what's your concerns. Nothing. Silence from the entire Tennessee General Assembly. So I sent a follow-up email and I said, gosh, I'm really sad that nobody even bothered to email me back at all you guys. Nobody bothered to just, how can I help you, Mr. Gentry? Nothing, crickets, right? So I sent a follow-up email and I said, gosh, I'm really sorry. Nobody even cares. But just to let you know what I'm going to remonstrate about, the Tennessee Board of Judicial Conduct is an unconstitutional agency that should have never come into being. It's an unconstitutional transfer of legislative power to the judiciary to oversee the judiciary, and it ain't frickin' working. And so I had Representative Garrett write me back, and he said, are you saying the Tennessee Board of Judicial Conduct should be abolished? And I said, well, I said, this is a big question. Well, actually, what he said, Garrett said, should the Tennessee Board, are you suggesting the Tennessee Board of Judicial Conduct should be abolished and that the House should have the sole power of impeachment? So I said, this, since the question was asked, I think this should be addressed to the entire General Assembly. So should the sole power of impeachment lie to the House? Well, it's in the Constitution. I shouldn't need to answer that question. You swore an oath to uphold the Constitution. Constitution specifically says the sole power of impeachment lies with the House. So whether the Board of Judicial Conduct remains a going concern is irrelevant. Yes, the sole power of impeachment is with the House.
Show me where it exists, or the power that process for bringing it into being exists, because a repugnant act cannot be brought into being, right?
Yeah.
So
I wrote him back and I said, if you guys want to keep this do nothing agency, that's up to y'all. I'll leave that to your wisdom. But let's look at the facts. They dismiss 100% of complaints. A judge has not been impeached since 1958, and we know they're all criminals. They get 1.4 complaints per day, and nothing ever happens. We're spending millions of dollars to pay through this agency, and they don't do anything. Why do we need them? They get 1.4 complaints per day. 1.4. You guys can handle that volume. That's not a lot. Why are we wasting money on an agency that does nothing? Here's the success. Tennessee Board of Judicial Conduct is history. They are no more. They are gone. That one's toast. They're calling it sunset. I don't care if you call it abolish or sunset or defunded, whatever the hell you call it. I'm glad those guys that protect the misconduct and aid and abet rights violations under color of law, I'm glad they're gone. You can call it whatever the hell you want to call it.
So that means what John just described is how you litigate an unlawful emolument, right? So the symptoms and the stuff that have been litigated, like in the case of Peterson versus Peterson, okay, that's the effects, okay? The cause is the unlawful emolument, right? So you remove the cause, the effect ceases. That's a maxim of law. And as soon as he's done, I'm going to share the proper way to argue that when he's on paper, when he's done, because this is before Congress that led to that question. So
this is, I'm going to share another success with you guys. Is I'm working with, not working with, that's a loose phrase that I'm using, but they're asking me like, so what should we do about impeachments? How should this process work? And a representative told me that he's working on a bill to create a process for people to file impeachments. And he's like, how is this process going to work? So what that tells me is Tennessee Board of Judicial Conduct is history. They're going to be sunsetted. But now they're looking at how is this process going to work in the House for receiving complaints? How are those processes? Who's going to hear it? What's the committee's going to be? All this stuff. So I wrote it up for them. I want to run through the redress that I'm seeking in this remonstrance, because this, you can bitch and complain, but if you ain't got a solution, you ain't got no reason to bitch. Because when you file a remonstrance, it's for redress of grievance. So it's just like it's just like a complaint. It's just like a cause of action. Here's the problem, here's the facts, and here's how we fix the problem. Here's the redress for it. So I'm going to run through this really, really quick. So this is the remonstrance. It was filed in the Tennessee Supreme Court, or the Tennessee Senate. And I've got a section in here, reforms demanded and redress of grievances, page 64. So let me jump to 64 here. So here's what I want. Impeachment of those found guilty of crimes committed in office. This is a no-brainer. For them to say no to that means that they are subjecting the people knowingly and willfully to judges who have committed crimes in office. So I think these guys need to be impeached. That's number one. Drug testing. If we've got a judge who has a substance abuse habit, or he's doing it for recreational purposes, we should know that. If it's a judge, coming from the upper class, probably upper middle class, is probably an expensive habit, and that encourages corruption if they need to pay for a cocaine habit or something like that. So let's drug test them. I have to take a drug test to get my job. I'm a CPA. I think it's quite reasonable, considering the power that these guys have, to have them take drug tests. I want live stream and recorded court proceedings. This I think is very, very important. Or this bullshit, when they post shit like this in the courthouse. Let me take it off the screen share here real quick. They post shit like this in the courthouse rules. And they say, no audio or visual recording devices. Tennessee Constitution says all courts shall be open. If you don't want open courts and you don't want people recording, that means you're doing some tricky crap in there that you're trying to hide. So if Tennessee doesn't want to pay for cameras in the courtroom, I want the General Assembly to say, you can't do this crap. If somebody wants to bring their own audio visual equipment, they can do it. They don't need the damn court's permission. So if you don't want to pay for it, fine. We'll take care of it. We'll let the people take care of that. And if I have to,
a right to media is retained by the people, in like the First Amendment.
All courts shall be open. The other thing I want with this all courts shall be open, star chambers, in-chamber proceedings, and any and all closed-door sessions of the courts with less than both the parties and both counsels, including pro se litigants, must be declared by session statute unlawful and prohibited. You guys can't go in the back room and figure out how you're going to work your way out of the crap you started. You're going to do it in front of everybody, So,
in and on the record.
So that's another thing. And
communications in the back room deals.
And this isn't something new. Senator Grassley, he's Iowa or Idaho? I think he's Iowa.
Iowa.
Is he Idaho? So he wants cameras in the federal courts. I'm not asking for anything crazy. We've got. I think he's a chair of the Judiciary Committee in the United States Congress. He wants cameras. I want cameras too. I don't think it's a big deal.
Right.
All courts shall be.
We hear all transcripts and everything. We just send over a video, and the appellate court and the Supreme Court can just watch the video. So no more transcripts. No more transcribing anything. Nobody, no big money in transcripts.
Yeah. So the Tennessee Court of Appeals, they pick and choose what they make available to the public. The entire court record. If you go on to Pacer and you open up any federal case, every single document that's filed is available to the public. And the Tennessee Court of Appeals, they pick and choose. And when the conduct of a judge or an attorney is called into question, they hide it. They will not make that available to the public. The appellant's briefs, Those are all concealed from the public. This, and here's the thing, Kirk. Tell me if I'm wrong. A court of record maintains a permanent record. It's always available. And in my case, they sent me a letter, said, we're going to destroy the record. You can come get it if you want. And I said, okay, I'm going to come get the record because I need that evidence to show Congress how corrupt the Tennessee Court of Appeals is. And when I go down there, there's 3 clerks standing around taking out stuff out of my boxes. And I'm like, what are you taking out? And they're like, well, we're taking out, the appellant's briefs, the motions that were filed in appellate court, all the orders. I'm like, why are you taking that out? They said, well, that belongs to the court. And I was like, well, did they pay for it? I said, I think that belongs to the people, but why are you taking it out? I was like, is this going to be part of the permanent record? And they said, no, we're going to destroy it. So I can't have it, but you're going to destroy it, right? Did I get that? Did I understand correctly? They said, yes.
They're destroying their corruption, the evidence of their corruption.
Right. Now, so it's willfully destruction of public property.
And they are no longer a court of record because they've destroyed the record. And it's not available and it's not stored electronically unless they got 2 sets of books and they got an electronic record where they keep everything that they look at, and then there's an electronic record available for the public. But Tennessee Constitution, all courts shall be open. Tennessee Court of Appeals, stop your corruption and start making the record available so we can see all the corruption that's happening in the lower courts. That's a big one. That's one I want. Now this one, guys, they got to give me this. They have to give me this one. And I said it right here. Respectfully stated, this demand cannot rightfully be denied by the General Assembly and must be put into effect immediately. And if I get to present in front of the General Assembly, I said I'm going to move for a vote of the joint houses and ask them to vote on this. In the Miranda opinion, the Supreme Court advised that we have to be warned. We have to be advised of our rights when we're being arrested. It is the same legal argument. We need to know what our rights are in a court of law. So here's the process. Upon commencement of any and all litigation, both civil and criminal, all parties to any case, both defendants and plaintiffs, must be advised and acknowledge advisement and understanding in writing of their constitutionally protected rights. This writing is to be evidenced by their signature and witnessed by a member of the court and recorded permanently in the court of record. So begin document. Here's what the Constitution says. All courts shall be open. Every man for an injury done in him and his goods, persons, or reputation shall have remedy by law and right and justice, sale, denial, or delay. Due course of law means you have a right of due process. Essential elements of due process as determined by the Supreme Court shall include: you have a right to be heard. You have a right to present evidence according to the rules of evidence. You have a right to present evidence orally. You have a right to confront adverse witness testimony of any person or persons face to face. You have an inviolate right to trial by jury in both civil and criminal cases. You have a right to a fair and impartial court. You have a right to record proceedings with audio or visual equipment if not provided by the court. If, in your opinion, at any time, if you feel you're being deprived of fair and impartial court, you have a right to stop proceedings, stay all orders, and demand trial by jury, because a trial by jury is an inviolate right, people. And then we're going to tell them it is a federal crime to violate constitutionally protected rights under 18 U.S.C. sections 241 and 242. If you have evidence beyond doubt that a member of the judiciary has violated any of these rights, you have a right to petition a remonstrance to seek impeachment of any judge to be filed with the clerk's office of the House of Representatives. Do you understand these rights? If you understand your rights, sign right here. I want that done in every court in Tennessee. I don't care what the freaking case is. If you cannot give that to me, then that means you want people to not understand what their rights are, which is in violation of Miranda rights opinion. Unconstitutional statutes, that crap's got to go away. Oversight of the judiciary restored to the House, and I told this is the process that I want. So complaint is to be accepted by the House. It is suggested a committee be put in place to review complaints. The voting members of the committee or committees should never include a member who is an attorney due to a clear conflict of interest. An attorney may be part of the committee to provide advisement. Petitioners have a right to attend proceedings and present orally. If the committee determines that a complaint is without merit, the complainant has a right to petition either the full House or request a review by jury of 12 from the jury pool, with proceedings to be conducted in the House hearing rooms with a House member present. If the jury concurs that the complaint has merit, the petition is presented to the House for vote. If crimes are evidenced, then the House concurs. Impeachment proceedings commence under Article 5. If the conduct complained of is such that it is incompatible with the trust and confidence placed, then removal proceedings should continue under Article 6, Section 6. Licensure of attorneys. These boards that oversee the licensure of attorneys, they hold licensure of attorneys hostage so that they could coerce them. This needs to stop. These oversight agencies for the bar need to go away. The Tennessee Code Commission must be abolished for obvious reasons. I want performance measures put in place for judges. And then, I don't know if you guys care, but I spent a lot of money in federal court. I don't want any damages or anything. I just want the money I spent wasting my time all the way to the Supreme Court. I'd like that money back. Where I want my pound of flesh is Judge Amanda McClendon violated my right of due process with fraud on the court, false application of law, and conspiracy to deprive me equal protection. I want her judgments invalidated and voided, and I want my pound of flesh out of these damn attorneys that started me on this process. And I wrote in here and I said, it's because of these two attorneys that I'm standing in front of you guys. So let me go kick their ass once and for all. And that's the redress I'm seeking in this case.
Well, and I think you're absolutely 100% true and accurate in that, what you're describing here is, of course, the other side is going to argue lex talionis, and that's an eye for an eye, a tooth for a tooth, and it's not lawful, and it's revenge, and you're threatening them, and all of those lovely word salad arguments they love to throw at you, right?
I'm not threatening them. I sued him to Thor. I just want the judgment invalidated because it was fraudulent, and I want my justice.
I get it. Let me finish, okay? So, what's actually being said here is, I had this exact same problem. I sent a letter of request to one of my former attorneys for my file, and was told that if I contacted her again, threatening her, she was going to forward the correspondence to the prosecutor. And I said, wait a second. How do you construe a request for my copy of my file as a threat in any way? What the hell is that about? And that's one of the actual first elements that started this, because I said, wait a minute, you sure you want to pick a fight with me? That's not a smart idea, and I know damn well Gary told you so. You don't want to pick a fight with me, because I'm like a bull. I'm a freaking pit bull, man. I'll get on your freaking leg with my jaw, and I ain't letting go. I'm a merciless bastard when it comes to that shit. Don't even think about it. And, you know, sure enough, that's exactly what they started. And I said, that's it. That's right. No mercy, baby. You decided you wanted to ride this train. We're going to ride it all the way through from Maine all the way down to Southern California and as many stops in between as it takes until we get there. And I don't care if you have to push before we
Here's a point that I want to make about those redresses. Drug tests for judges, impeach bad actors, get rid of these agencies that don't do anything. If you don't want to put cameras in the courtroom, let us bring our own. And most importantly, people advised of what their right of due process is. There is not one single cost assigned to the state for those things. Those are cost-free reforms. Not only are they cost-free, they're cost savings because they abolish unconstitutional agencies. I'm coming in there showing you guys how to save $10-15 million a year. You ought to give me just a freaking point as a bonus because I just saved you $10 million. You know, well, I'm serious.
They don't want to save money.
Every redress does not cost a single penny out of there. And if you cannot grant me advising people of their right of due process, that means you are corrupt and you want to violate rights. I don't know how they're going to say no. I really don't.
Well, I mean, this goes right back to history here. Our petitions have only been met with repeated injuries. So this is going to be the test of time again. Are we going to be met with repeated injuries, or are they actually going to perform their duties under the law?
I've already been met with repeated injuries. I've gone through, I don't know, 59 judges so far. 7 agencies I've gone through so far. You know, I've done I have sought redress in every possible way.
Wait. No. You did not follow due process of law. You have just now, with filing this petition of remonstrance, have just now finally followed due process of law.
I'll tell you.
I mean, don't you think it was important for somebody along the way who purports themselves to know the law that says, well, I can't make those arguments, but I know where you can make those arguments, right? And hey, bud, here's my business card. When you get your scope document, you come back and see me, and I will represent you in court if you need counsel for any criminal whatever. Well, and there are some cases that are going to have criminal elements, right, where they may require an attorney. We don't know. Not every case is cookie cutter, right?
Well,
so
that would be for
if somebody says they've committed this crime and it comes up that no, they didn't, right? If the person who's accused of the crime doesn't know how to make proper defense arguments to defend themselves, then assistance of counsel, whoever that counsel they would choose to represent them or work with them, right, should have the freedom and the ability to make the necessary arguments or continue on with the line of argument that led to the scope document in the first place, right? So as many times as I've heard I can't make those arguments, but yeah, you got one hell of a case here, right? And we've all heard that. How many times? Let me count the ways how many times I've heard that. So
I tell you, I put a good 150 hours into that remonstrance. And
right. Oh yeah, I mean, and it's easy to do. It is very easy to do, which goes back to when you actually file the document, you're like my original petition, the project you and I worked on together, right? that was the original petition from a couple of years ago. I've just been updating them as I go and basically told them, hey, even the judge has mandated, you guys need to see this. If we're going to do oversight, I'm going to assign a mandate and make sure that that the entire record is being reviewed. In this case over here in Texas, the appellate court said, we believe in this so much, we're going to maintain this record for 6 years. So they didn't dismiss for lack of jurisdiction. They dismissed for want of jurisdiction, in the simple fact that the Court of Appeals is not a criminal court. It is a civil court. They're saying, look, we want jurisdiction. There is a want for jurisdiction, but that needs to be done that needs to be prosecuted in a court of law. So, yeah, here's the record. We're going to keep the entire record that we have, right? You give it to what you have with your other agencies. Would that be the Texas law enforcement? Pick one. Excuse me, or whatever. But once the scope document for prosecution is issued, this mandate is an invite to whoever that prosecutor would be to come and get what we gave them in the court and say, hey, we want we want this jurisdiction, this criminal indictment, we want it, and here's our contribution to it. That's what it says. So, well, and one of the ways that we got similar to what I'm
update on the
right
Texas
now.
case.
Huh?
Not ready to share that. What? Any update on the Texas case?
Oh, yeah. As a matter of fact, we were discussing that earlier as to when we're actually going to come out, do the document dump. Basically, what John just did, we're going to take his entire case, go through the brief, go through the federal court's orders, and then show how we work the process kind of forwards and backwards, and played a little bit of political boxing, right? Some left hooks, some right crosses here and there, right? And we did a little bit of political, little Texas political boxing, right? And that's why I said y'all are going to have fun when we go through that one. But I got a couple of paragraphs here I want to share with you guys, because this goes to pretty much how I was able to get into the oversight committee for review. Everybody's always asking, how can I get into the oversight committee for a review? That's the single biggest question that I get. Okay. So in order to do it, you have to make the argument correctly, right? So as I got down to the, I would say close to the end, this is the 9th paragraph of I think 11. Right after I cited this rather long federal judge's decision by Kenneth Hoyt, I said, okay, now that we can clarify through this above decision the exact judicial standpoint in this matter of unlawful enforcement, okay, this office, acting in its official fiduciary capacity, is now prepared to make its final report to the U.S. Congress, as well as the President of the United States of America, the corresponding state government branches, and related entities, without audit ability to remove challenged, defeated legislation, in other words, clearing the record. These court actors are claiming full faith and credit to continue to pass crap. What other word can I come up with than crap, right? So the simple fact of these.
I don't know if I'd use crap, but.
Well, it's all, hey, I didn't say shit. I was thinking it, but I didn't say it. So the simple fact of these emoluments now being owned by specific men, families, or sets of men, which is language that is in the emoluments clauses. That's why that's why I put it in bold, right? No man, family, or set of men, right? As corporations, also clearly in violation of the emoluments clauses cited as they're now traded on the New York Stock Exchange, right? And it is a cursed construction that corrupts the text, right? The construction is the pyramid scheme, which of course is part of the evidence packet as I outlined it. I'll show that to you in a second. These entities are clearly in treason against the Constitution of the United States of America, the Constitution of the state of Ohio, the Constitution of the state of Florida, as they absolutely refuse to enforce perjury statutes as laid out by Congress to ensure the integrity of official records be maintained at all times, right? Not to mention the obvious, ridiculous monopoly leveraging tactics they employ, right? Swift, decisive congressional action, right? Now, let's look at current events. Where are we now? Even the president has decided, hey, you know what? This is Congress's job. Let's make those son of a bitches do this. In other words, go in there and repeal all of that bullshit Agenda 21 crap, kick these bad actors back where the hell they belong, right? This is what reinstituting the republic looks like, right? Some of it you're going to see, some of it you're not going to see. So when it comes to standing your ground, which is on the cover of the document, as I've shown more than once, this is, okay, the people have said, we don't want a corporate government owned by any men, families, or sets of men. That's in the Constitution. That means those emoluments are not lawful. That means they have to go back in there and unscrew that shit, right? What does that do to a corporation? It shuts it down. Okay, so now that we understand why we had to shut it down, just like any other business, right? If you're going to close a location, a store, a branch, whatever, you have to close it, lock the doors, and then take stuff out the back and leave the empty shell, right? That's just the process. It's the way it is. Been doing it for years. I could go through it and bore you to tears, but I don't think you'd care. Okay, these let's see. Yeah, swift, decisive congressional action efforts to will have the effect of transferring the full power and authority of oversight of the judicial process back into the hands of the people of these respective states where it belongs. So what John just did with getting rid of that specific one emolument, that unlawful emolument of judges overseeing judges, right? This is me taking my hand and clean sweeping the whole damn desk off. I'm not just picking up one piece at a time and doing this over here and throw that one over there and do this over here and do that over there. So no, I got this big shovel. It's called the Emoluments Clause. We're going to shovel that crap and throw it back out into the sea where it belongs, right?
I'm taking that sniper approach, Chris. One at a time. One at a time.
As a Force Recon Marine, maybe that might be how you do it. Me, I'm a freaking bull in a china shop, baby. After 30 years, I'm like, you know, I'm a freight train, man.
I mean, you think about that, though. That's a big deal that the Tennessee Board of Judicial Conduct, you know, those guys have been protecting judges for decades, and they're toast now.
Right. Basically, what
Are you talking about?
I did was I went in and said,
this Tennessee Code Commission, there is no doubt in my mind they are going to be toast. They are gone because
no. I was trying to listen to what Kirk was saying.
What I was saying is, are you trying to pull the plug on this and drain the shithole?
Yeah.
Yeah, something like that. So pursuant to Article 1, Section 1, that's, all political power is inherent in the people, right? Following due process of law, not the court. So all of these attorneys who are out there bitching about what E-Clause does and how full of shit I am, well, guess what? Now y'all can see for yourselves. Don't take my word for it. Go verify that what you have seen on this show tonight does work if you do it properly. There is a way to challenge authority, right? As long as you do it lawfully, you will be heard. And that is all the way up in DC. So I'm going to stop sharing here now and let Kirk take the wheel back over.
I just want to let people know out there what the new plan here is for Kirks Law Corner. So Mondays is going to be me basically solo, going back to the original intent of Kirks Law Corner, which is educating the people on what their rights are, where they come from in law as it is written, and how to effectively defend your rights. And then Wednesdays is going to be like this. We're going to be talking about what we're doing, the emolument stuff. And then Fridays is going to be the fun night. We're just going to randomly talk about stuff. And I know we used to do kind of a call-in show, but that kind of fell on its face. So Fridays will be more or less watching comments, watching questions inside the feed there and trying to keep up with those. That's the new plan. I did Monday. I did a basis of law and where your rights come from in law. And I'm going to get into things like writing documents and things like jurisdiction, how to appear specially, right? Because that's part of the law. You have to notify them who you are and how you're appearing. When you hire an attorney, they have to put in their notice of appearance. So I'm going to highly recommend that people stop hiring attorneys. And this is what I'm going to teach you. I'm going to teach you how to not represent yourself, because you can't represent. You can't represent yourself. You are yourself. You are man, you are woman, or you are, in this instance, in a petition of remonstrance, one of the people. Those are the only three terms that we need to know. Anybody tries to use any of those other terms, that's all word salad, right? You are a man, a woman, a creation of God, or you are one of the people. That's it.
I want to hit a comment Nate just did, because this is important depending on the state that you're in. So Nate said, he said, advice for when you file a remonstrance, you have to exhaust all means of redress. That's true in some jurisdictions. I was looking at the New Hampshire Constitution, and
that is the form of redress.
And in New Hampshire, it's saying, after you've exhausted everything, then you can petition the legislature. I think it was New Hampshire that I was looking at. Depends. Tennessee doesn't say anything about exhausting all avenues. For me personally, I did. I went through every possible avenue, humbly seeking redress. And I just wanted rights enforced. I wasn't trying to get money out of this. I was just trying to say, I want due process, man. So it's a good comment though, Nate. It depends on you have to read your constitution in your state. Some states require you that you exhaust all means of redress before you address the Congress. Tennessee, it doesn't say that though. And I will say under Article 4, full faith and credit, and privileges and immunities clause, who gives a shit what the other states say, because Tennessee says it, my rights apply to you. Right, Kirk?
Say that again?
Well, so I was saying some constitutions say you have to exhaust all remedy. But because my Constitution doesn't say that, you just use my Constitution under Article 4, Section 1 and 2.
Okay, when they're saying you have to exhaust all remedies, here's the reality. When another man, agency, whatever, an agent of an agency trespasses the law, that automatically creates a right to a cause of action. You have to defend yourself to begin with from that initial deal. But the right to redress your grievances with bad policy or bad actors in government is the proper process. And that is a petition of remonstrance. So that is the first line of defense. So you file your paperwork in the initial kangaroo de facto courts. And, you know, I don't want to go way off into this, but we go right straight to the legislature. And this will be something I've already started at the beginning of laying down, like where the law was laid down, declarations. And the word salad out there, Mindy asked, pro se? Yes, pro se is a word salad. It's called sui juris, being of lawful age, 21, of sound mind, and perfectly capable of handling your administrative duties. Okay, you must make your court of record. Okay, courts are not specific to the judicial branch, to the legislative branch, because the preamble, right? What's the preamble say here? Let's read that. This is what we need to comprehend here. We, the people, in order to form a more perfect union, establish justice. Where do we establish justice? Not government. We, the people, establish justice. We establish that in the court of justice, in the first branch of government. That's us. We, the people, we're self-governed. Okay? So that's the main thing we need to comprehend, is that courts are not specific to any branch of government. And a court of record is nothing but paperwork. That's the whole entire court. The court doesn't actually exist in the sense of a building inside a room with walls and all that stuff. That's out of Black's Law Dictionary. Courts are supposed to be out in the open with no walls, no ceilings. This is out on the streets, right? Public record. That is the court of record. So I'm going to teach you. That's Monday nights. So Monday nights will be me solo teaching you how to write these documents and how to effectively defend your life, your liberty, and your property from tyrants. Okay?
I don't know how you do 3 nights a week, man. This is exhausting doing too, man.
But see, this is what I'm doing now, right? You go to work all day. This is what I do all day, right? I'm studying, I'm researching, I'm teaching, I'm educating. I show up for other people's court hearings. I show up to county commissioner hearings. I go to bat for people. This is what I've dedicated my life to. So, which brings up the point of needing donations, because I don't have a daily paying job. This is what I'm providing, an education for the people to restore the republic, to restore your rights back to you, and how to claim those rights and how to effectively exercise those rights, and put these people in their place as the servants or tyrants, whatever they may be. If they're tyrants, I'm going to teach you how to put them in their place. And then, you know, that's just the way things are. So a lot of the courts that we're seeing today and we're being subjected to are unlawfully created courts. They're not even supposed to exist in our form of government in the Constitution. And we're being subjected to some of those courts, like allegedly courts of law and courts of equity. No, it all falls under the common law. Those courts that we're talking about there in the Constitution in Article 3 are for those that are bound by the Constitution, Article 6, Clause 2 and 3. All of whatever's in the Constitution only applies to those that are bound by that process. To make that clear, unless you're a elected official or appointed into a position of public trust, the Constitution does not apply to you. You are man, right? We are acting under the common law in the private. The only way a suit between a man and a man is to be through the common law courts. See the 7th Amendment or the 7th article of the Bill of Rights, because they are articles in addition to, as an amendment to the Constitution. They are not amendments. That's the part that they leave off of the Bill of Rights. When you actually read the top portion of the Bill of Rights, that's what it says, as it is written. But they purposely hide that, just like the preamble, right? We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility. How do we ensure domestic tranquility? By going to the court of justice in the House and the Senate and creating law. We do, right? And then what is that? Provide for the common defense, not government, but we, the people, provide for the common defense. What is the common defense? We're not talking about taking up arms and defending the nation. That's not the common defense. That shouldn't be an everyday thing, right? What happens in the common law defense? And what one does in their defense is to be considered legal. That's a legal maxim of law. So you have the right to the assistance of counsel of your choice, and we have the right to contract our labor as we see fit. Because why? You cannot license the practice of law. See Schwer versus Board of Examiners, Sims versus Ahrens, see the 6th Amendment, see the preamble to the Constitution. There is no authority there. That would be, see the 10th Amendment, powers not delegated, right in the preamble. Those are powers not delegated to government. Those were retained by the people, right? Because that's what it says. Promote the general welfare and secure the blessings of liberty to ourselves, not to government. That's not what we instituted government for. And that's not what it says in writing. The compact and the contract for the compact's Constitution, the contract is when they take that oath or affirmation. That's the contract.
Well, I'll tell you one thing. We have their attention. There's no doubt.
Right.
They're starting to change some things now. I'm really excited. I think that the time is right now, and I think that in this one that I've done, I'm really starting to get some support in the House, and I think there's a lot of them out there that are like they're trying to wait to see what everybody else does. But I mean, you can't deny these things. You know, you can't deny a person being made aware of what his rights are. You know, you cannot keep judges in office that have been evidenced of crimes. You know, you can't do these things.
And again, let's talk about that just for a second. We talk about where's your standing in law, okay?
Mm-hmm.
How you claim and exercise a right, okay? Believe it or not, actually exercising the right is claiming the right, right? So as strange as that sounds. And one of the reasons why I got a text message and I want to answer it because I know he's watching. As far as how was I able to write a parliamentary inquiry as well as the, in doing my reporting the way I do it, not by not calling it a remonstrance or something else. Okay. I got the parliamentary inquiry privilege exception because of this document. I have my own oath of office. I have my own specific set of emoluments. And that's please tell me this thing didn't freeze up again.
It's there.
Okay, so there is my oath of office for the this is the one from 2016, but the new one that is still valid for about another 3 or 4 years is the exact same thing. It's just the dates are different, and I haven't scanned it. But this is what it looks like to have a specific emolument privilege, right? That does what this was designed to do. Go in and, tell the truth, right? Is this person the person they say they are? That's what a notary does, right? Identifies for the court or for any specific government function, the person who is standing before them is verified as that person, right? So I said, okay, because part of my credential says that verification of the truth is part of this job description. I'm going to take this tool, this credential, and I'm going to enter a parliamentary inquiry into Congress, right? To my knowledge, this process that I've created has never been done. So
right, it's
a little bit scary to jump in and do stuff like this. And I'll be the first one to tell you, I have often wondered, how was I able to, get away with this for so long without, some form of retaliation in some form or fashion. And to be completely honest with you, still working on that.
I want to hit a last comment here really quick.
Second, John, because before I finish for the night, I want to also share this one last document. To what Kirk was saying earlier about Nate's case, this was the order we got from the federal court that cleared his name. So when we come out and he and I are just going to do this on our own. When we come out and we do the full document dump, we're going to start with how we got this order, right? So that said, I haven't finished the complete presentation, getting it ready yet. And when I do get it ready, Nate and I will be going live from probably the Stephen page. Will be my Zoom account, and I'll be sharing it as usual. So this way we can go in there. He and I can just back and forth and, not lose our place and have too many irons in the fire, so to speak. So
one thing I'm about is solutions. We all know the freaking problems out there. I'm about how do we fix the problems, and that's what all three of us here are about, is getting to the root of the problem and fixing the problem. So first, we're going to remonstrate into our states, and I encourage you out there to find people in your state, come together, file together, use my work, use Chris's work, use Kirk's work. My petition of remonstrance is all over the place. It's on the website, wethepeople50.com. Go to the website, go to resource documents. You can download it, use it as a template. Chris is on Amber or eClaws now on Facebook page. Kirk's got tons of stuff in the Kirks Law Corner group. So we're giving you guys everything you need to do this. Get out there in your state governments. In Tennessee, it is working. Tennessee Board of Judicial Conduct is history. And I guarantee you the Tennessee Code Commission is going to be gone too. And that's the deep state bastards that have been construing our law to benefit the bar and the attorneys. So it is happening, people. We are fixing this problem. Now here, if the states don't want to unscrew this mess completely, we're going to still continue to come together as a people through We the People Facebook group and our page, and through Kirks Law Corner here, and through Chris's page. And if we have to, hundreds and thousands, millions of us, and I've got other groups that I'm working with, we could probably pull together 1 million people right now. I'm not kidding. We can probably bring 1 million people to remonstrate to the United States Congress right now. And if the states will not take action and fix these problems, then we're going to remonstrate to the United States Congress with hundreds of thousands of us, and going to ask the question, have the states forsaken their Republican character? Because we are guaranteed in our federal Constitution a Republican form of government. And the basic tenet of a Republican form of government is the right to redress a grievance by petition or address of remonstrance to our government. So we will get there, people. Get together in your states, use the work that we've done, file it in your states, and then if the states won't do anything, we'll go together to the United States Congress with hundreds of thousands, if not millions of us. We're going to make it happen, people. Time is now.
Mm-hmm. So if if you'd like to make a donation, personal donation to me to help support what we do here, you can do PayPal, Kirk_Pendergrass at hotmail.com. You can do a postal money order, checks, cashier's checks, whatever. The address is on the page here, 6477 West Fairview Avenue, Suite C, Boise, Idaho, 83704 or 5. I can post that on this one here too, but you know, Zoom costs me $55 a month. I have the Adobe Acrobat DC Pro stuff to help write documents, transform and all that fancy stuff, internet, the office, everything it takes to make this all happen. So if you would like to support me, that would be greatly appreciated.
And I would love to be able to go pound on my legislator's door every day, but I'm not willing to give up my job, guys. I would like to do this full time, but I kind of like my house and I don't want to lose it, you know. So I encourage, Kirk, that takes courage, that takes courage to say, this is what I'm going to do. So I hope it goes, $5, $100, whatever you can do. Kirk will appreciate it. I will say this unequivocally. The work I have done, so many people have helped me, and especially here on this forum, have helped me. I think it's really important, the work that we're doing here on Kirks Law Corner, and I never could have done it without Chris and Kirk, and in particular in my remonstrance, the argument or the claim that Kirk made about these unconstitutional code commissions who are bar members writing our laws for corrupt purpose and to their benefit, and it's pretended legislation. We're going to shut it down in Tennessee. We need to start shutting it down across this country. This is, in my opinion, it's whatever you want to call it, the cabal, the deep state. But the work that I've been successful with, there's so many people out there that have helped me, understand how to argue, and even the failures of people out there have helped me learn what doesn't work, what ain't going to happen. So it's hundreds of people have helped me, but particularly here on Kirks Law Corner, I have learned so much, and Kirk strengthened my remonstrance beyond belief. We actually had, the three of us, we had a private phone call, and it was pretty heated, and Kirk was pissed off at us that we weren't getting it, And when I finally started doing the research and read the material that Kirk referred me to, I was like, holy shit, this is it, man. So support Kirk. We're doing good things here. This is the time, people. This is it right now.
Yes.
I was watching, I don't know if I can find this, but I was watching the Wembley concert, the Live Aid Queen at the Wembley Stadium in Great Britain. And I was watching the song Under Pressure that they performed at Wembley. And there's a lot of lyrics in there that sound a lot about the work that we're doing right now. Just my weirded out self.
All right. Well, thank you all for tuning in. Like, follow, and share here on Kirks Law Corner. Like when you start the video here, it'll say get notified when we go live. You might want to get on that so that you know when we go live, you get notified. Other than that, Mondays, Wednesdays, and Fridays, 5:30 p.m. would be Pacific time, 6:30 Mountain time, 7:30 Central, and 8:30 Eastern, Monday, Wednesday, and Friday now. So, and then E-Clause LLC Group, formerly known as Amber and Stephen. And then Chris has got the page, Stephen, which is where he goes live from now. And then John runs the private group, We the People versus the 50 United States. So that's the group there that John runs. And then John has the website, We the People, Victor50.com. Lots of great info on there. Get on there. Get your email signed up so that you can get notified if anything happens. Facebook goes down, whatever goes down. We still have a way of communicating through email. So when anything happens like this petition of remonstrance that John just filed, you will get a notification by email that this was filed so that you can go find it, where to find it.
Yeah, that my petition of remonstrance is available on WeThePeople50.com and in We the People versus the 50 United States on the Facebook page. So you can go get it. It's involved. It's heavy rating, but yep. If you can find somebody strong in your state and then come together, 1, 2, 10, 15, 1,000 people in your state. It's how we get shit done. I am telling you, yes. There's not a legislator, there's probably not a judge in the state of Tennessee who doesn't know who I am and what my work is about. As a result of my petition of remonstrance and the work that Kirk showed me about the Tennessee Code Commission, I have demanded impeachment of Supreme Court Justice Bivens for declared acts of tyranny. And I have demanded impeachment of Attorney General Herbert Slavery III for declared acts of tyranny, because what they are doing in this Code Commission is exactly the same grievances stated in our Declaration of Independence. So they ain't liking it. And that's why they're trying to keep me out of the House, but I'm going to get it in the House. I guarantee it. I'm going to get in the House. It's going to happen.
Well, now that it's filed with the clerk of the court of justice in the Senate, it's pretty much going to force it into the House. I mean, they cannot deny you your right to access justice, your right to due process of law.
I can guarantee you, beyond any doubt, it is going to be before the House. No doubt.
It has to. That's part of the process.
No doubt in my mind, it is going to be in front of the House. They can try every little shit they want to, because I'm gonna say, read the rule book, guys.
This is going to be the first hurdle to get over, is the fact that they're what we call gatekeepers. the very first person you talk to is going to attempt to deny you, feed you a line of crap that says, oh, well, you can't do this or you can't do that. And, oh, you got to have this over there. Well, the rules say, I don't care about your rules. The law says that we, the people, laid down, ordained, and established as the law of the land, the common law, the Bill of Rights.
Even their rules say it. Even their rules say it, Kirk. Even their rules.
I know. But she was trying to tell you, well, the rules say it's got to be presented by a member.
No, she said the process, and I'm like, what process? Made up bullshit.
Well, and
but the rules,
I mean, it's called
the rules. No, I want to say it. The rules specifically say that they have to that questions become before the body by communications. I've communicated. I emailed them all. The question is before the body.
Mm-hmm. So
right, and well, and for those of you that don't actually have the book to take with them and show them the way the three of us do, you can print out you can take excerpts, the Mason's Manual that I put in E-Clause, and print out the section of the book and take that section with you. You don't have to print the whole document, right?
Right.
You just print what you need. So also in that same file section of E-Clause, if you want to know what the document looks like that led to the questions that Dianne Feinstein asked the Attorney General yesterday, that document is called SCOTUS question. It's in the files section of that group. Okay, so it's been there. It's been there posted for free. You guys can download it, take your time, read through it. My email address is right there on the cover, on every one of the cover pages at the bottom in the center. And you can, I don't have the Facebook app on my phone anymore. It's killing my battery. So I had to get rid of it. And imagine that. Now I can talk on the friggin' phone all day long without having to have a charger following me around like a tail stuffed up my ass. So.
You don't have one of these?
You see them? Yeah, exactly. You know, I'm just saying.
This thing will jumpstart a car.
Right?
Actually, it does. It has this plug right here. You plug it in. I even bought one for my mom for Christmas a couple years ago, and she carries this around in her car. It literally jumpstart her car. It's awesome.
I'd laugh my ass off if you could jumpstart a car with a cell phone.
I gotta share this because it's just funny. So the clerk, the chief clerk, Tammy Letzler, who is the chief clerk for the House of Representatives for the state of Tennessee, she said, well, you have to file, you have to have a member file on your behalf. And I said, under what rule? And she said, well, that's our process. And I was like, what process? That hadn't been done since 1850. Well, it's our process. Where's the proof of your process? Well, I don't have any. So I said,
your process comes from here.
Well, I got out my phone, and this is funny. I got out my phone and I started to put it on video, and I said, will you say that for the camera? And she ran in her office and closed the door. That's a deprivation of rights. It's actually a federal crime. I don't want to punish these people. She's a pawn, you know, she's not worth going after. She's under the influence of the bad actor bar members. She's probably a nice person. She's just scared for her job.
Drinking the Kool-Aid, right? Or should I say forced to drink the Kool-Aid, right? So, you know, again, this is why I said the more we've done this, the more we found out exactly what they don't know. And because when we walk in there and we now educate them and we're following due process of law, right? In spite of everybody telling us, you can't do that. You can't do that. You can't do that. Right? If we've heard that once, John, we've heard that 1,000 times over the last 3 years.
Oh my God. Yeah. I'll tell you what though, and this warmed my heart was I had a representative tell me I'm ashamed. I stand for the Constitution, but I'm so ashamed that I didn't understand all of this stuff. I didn't understand what was going on. And so we're opening their eyes. I mean, there are good legislators. Make no mistake, there are good people in there. They're just scared. We're going to give them the courage. We're going to give them the tools. We're going to instruct them, which is also a right guaranteed to us to instruct our representatives. And they're going to do the right thing. I believe they are. How the hell do you sit back and say, nah, I think we should let these judges and lawyers keep violating rights and extorting people under color of law and stealing kids? Yeah, I'm okay with that. They're not. They are not. They just don't understand what is going on. But once we educate them and we present them with the evidence through remonstrance, when they understand that they have become tyrants, when we hold a mirror to their face and they see the monster that they've become, they too are going to be ashamed and they will change. I believe that. Yin and yang, man, there's good in everybody. So.
Yep.
Except for the attorneys. I don't know if there's any good in them anymore, man.
Right.
Well, got to remember what the evil forces that we're up against here, and some of those people in the House and the Senate are part of the evil, and they're not going to want to let this power go. They're going to fight it tooth and nail. And then not only that, those over there in the judicial branch and the bar protecting their everything that they get, their unlawful advantage, profits, and gains from doing this business, are threatening, would threaten the other people, the actual people in members of Congress, and the real people that aren't members of the bar, that haven't been brainwashed, and even some of the members of the bar that haven't quite been tainted yet, that get it already. There's some people out there that I know that are attorneys that get this. So
yeah, I have turned 2 corrupt judges who rule in my favor, like absolutely corrupt, under the influence of the bar judges, and they ruled in my favor. It can be done. You just state the facts, you state the law, you say, here's the mirror, here's what you look like. Is that what you want to be? Are you okay with that?
Mm-hmm. Yeah, I mean, like many of us, I made the conscious decision. Is fighting with my ex-wife more important than making sure my children have a future? That took me about 0.68 seconds to figure out the real answer to that question. So, again.
Say that again?
Huh?
Say that again?
Right? What, it took me about 0.68 seconds to figure out the right answer? Yeah, I mean, and again, this was the, when Benjamin Franklin said, when he was asked, what have you just wrought? And he said, a republic if you can keep it. And it was the, if you can keep it part that was like, right? I had to keep it. I had to research and find what an emolument was, and then start, the inquiries as due process of law, right? And the more, I started to ask, hey, dude, that's an emolument, right? They start with I'm doing the tie and the sweat beads rolling off their head. And it's like, did that just kind of like, punch you in the mouth or something? I mean, what happened? Right? So.
Did you just swallow some caps in there or what?
Hairball, right? So
that's not what your country can do for you, but what you can do for your country.
This is the one that drives it home for me. The last paragraph of the Gettysburg Address. But in a larger sense, we cannot dedicate, we cannot consecrate, we cannot hallow this ground. The brave men, living and dead, who struggled here have consecrated it far beyond our poor power to add or detract. The world will little note nor long remember what we say here, but it can never forget what they did here. It is for us, the living, rather, to be dedicated here to the unfinished work which they who fought here have thus far so nobly advanced. It is rather for us to be here dedicated to the great task remaining before us, that from these honored dead we take increased devotion to that cause for which they gave their last full measure of devotion, that we here highly resolve that the dead shall not have died in vain, that this nation under God shall have a new birth of freedom, and that a government of the people, by the people, for the people, shall not perish from the earth. That is the most profound speech to me ever. It is the most meaningful to me as a former Marine, understanding the sacrifice of lost comrades who have died in training and died on the battlefield, died as a result of their service. That's why I'm here, that they shall not have died in vain. So many people have fought, died, sacrificed limbs, sacrificed their families. That's why we're here, people, that it wasn't in vain, that we restore this nation. And I believe the work that we're doing, and that this remonstrance, parliamentary inquiry, this coming together of the people is going to result in a new rebirth of freedom. And this nation so conceived will not perish. We're going to continue as our founders intended, but we have to fight for it. Every one of us have to perform. It is our duty to do this. It is absurd in the Tennessee Constitution. The doctrine of non-resistance is absurd, slavish, and destructive of the good and happiness of mankind. It is absurd. We have to fight back. It's our duty, people. So get out there, spread the word, talk to anybody, everybody about what the hell is going on. Do not present yourself as a victim. Present yourself as a patriot, fighting to preserve the intent of our founders.
Expose corruption,
vocabulary,
and reform.
Right. Vocabulary words. Remonstrance, emoluments. Those are the vocabulary words for the show tonight. And what was that? What was that character on Sesame Street that used to do that? I even forget.
Big Bird?
But was it Big Bird that used to do vocabulary? I know the Count used to do the numbers. I remember that. 1, 2, 3. But
I don't know if it was no.
I don't know.
It wasn't Cookie Monster, was it?
No. Cookie Monster, he did cookie, But I don't remember off the top of my head. Anyway, it just struck me funny. But, yep. Remonstrance, emoluments. Those are your two vocabulary words for the show tonight. And I want you to take those and go review the documents. We've put them out there for you guys.
Elmo.
And elbow, thank you. I just, I've done what I can do, and as Kirk and John have, to try to leave as much of my document vanilla as I possibly could. So when you take my stuff out and you put your stuff in, it does, the translation does not get lost. I literally wrote the process which doesn't change. The only thing that changes is your specific fact, your original trespass. Where'd the wheels come off the wagon? Whatever. And, that changes the res excipiendo fit actor. Like, what was it? John Kirk was saying, hold that mirror up to their face, right? Here's what you look like, buddy. And that's one of the reasons why I wrote the negative nexus process the way I did, because I wanted it to be as universal as possible with as little requirement and input from me as it could possibly be done. So believe me, when they see that negative nexus, they know damn well who wrote it. They know damn well where it came from. And if push comes to shove, they know that I'll fight to defend it if required, because I've already had to do it about 3 or 4 times, and they've lost every time. Let's just put it that way. So it took me about 10 minutes to go in there and smack them around a little bit. But it is what it is.
All right. For real this time. I'm ending it. Have a good night, folks. Much love out there. Hang in there. Keep studying. Keep reading. Keep following us. Get in these private groups that we have going on. We got in the file section there. There's lots of stuff there to read, learn, and educate yourself. So nobody else is responsible for your education but you. So ignorance of the law is no excuse. Much love, folks. Thanks for tuning in.